Suspended South Gauteng DPP advocate Andrew Chauke finally speaks. An explosive evidence they tried to hide from the president has come to light. Key documents that could have cleared him were omitted from the memo, and Chauke says this was no accident. For 14 years, he's led high-profile cases. Now he must defend his record while critics question, is this justice or a political setup? Watch this video to the end and see the incredible revelations yourself.
Remember that the criticism in paragraph 10.4 of the opinion by Mr. Halley is that after the delivery of the SCA judgment, you took too long to decide. And in any event, you decided not to proceed with the matter charge. Okay? Now, what did the SCA actually say should happen? Which is at paragraph 54.3 of the order in CL 00371.
The order reads as follows. It is recorded that the following undertaking has been finished on behalf of the first appellant.
And who is the first appellant?
The NDPP.
Yeah. And who was the NDPP?
Then it was Mr. Ngasana.
Yes. Thank you.
A, to decide which of the criminal charges of murder and related crimes that were withdrawn on 2 February 2012 are to be reinstituted and to make his decision known to the respondent within 2 months of this order. B, to provide reasons to the respondent within the same period as to why he decided not to reinstitute some, if any, of those charges.
Yes, now this is the point, is that so he does deal with it twice, but your point is that he deals with it in a manner that is inconsistent with the judgment of the SCA.
Indeed.
Yes, thank you. Now that would be a fair criticism, that's not personalized, is that correct?
I take your counsel, Chair. If I appeared to be personal, I still apologize if it came out that way.
Is the Judge of Appeal talking?
Yes. Now, thank you. Then there was an opinion by Ms. Moroka SC. I think we've dealt with that. And then there is the memorandum by Advocate Batoyi to the Minister of Justice and to the President.
Yes.
Is this the memorandum you said omitted the opinion of Advocate Kock, which exonerated you?
Yes.
Yes. Now, I think we need to look at it because it is a very, very serious allegation that the piece of evidence that exonerated you from one of the Deputy National Directors of Public Prosecutions was actually withheld from the Minister and the President at a critical time when they had to make a decision about whether to convene this inquiry at all.
Indeed.
Leonard Jr. would find it now. So that is the, if you go back to the Ms. Shamila Batoyi statement at SB 10266.
Advocate Moroka's opinion not at LO 001064.
Yes, Madam Chair, yes, it might be there.
This is the statement.
Yes, now I'm looking at the opinion, at the letter from the minister, from the NDPP to the minister, at reference at 47.7 of Advocate Chauke's statement.
Yes.
Now, the allegation you make here is that it omitted the opinion of Advocate Kock, which exonerated you.
Yes.
So that's what I'm saying is a serious charge, because it actually amounts to misleading when you don't give the president the right information on which he must make a decision. Now, that document is at SB 266. Do you have it?
I'm trying to get it from the computer. I don't have it on the.
Yes, I think you had the annexures to the Batoy statement. Do you have it?
You're referring to the memorandum by the Kock to the.
No. I'm not.
The one from the NDPP to the minister.
Correct.
Yes.
So that's SB 10266, correct?
Yes.
Now, it's written by Advocate Batoy to Minister Lamula, and it's dated the 18th of August, 2023, correct?
Yes.
Now, if you turn over the page where it deals with the information that is in front of the NDPP.
Yes.
So the first one is the annexures that are there is Annexure A, which is the Kock report, correct?
Let me get to that.
That is referenced in paragraph 2 of the statement.
Of the submission.
Yes. So if you look at paragraph 2, it has reference to Annexure A. That is the report by Advocate Rodney Kock.
Yes.
Now, then the next document is a request by Ms. Batoy to yourself to make representations, which is Annexure B.
Yes.
The next document, which is paragraph 4, is your response, Annexure C.
Yes.
Then the next one is, yes, but it was subsequently forwarded to the President after you raised it.
Of course. Yes.
And we've never been furnished with any explanation whether that omission was deliberate, to mislead, or was inadvertent.
I'll take the first option.
Yes. No, I'm just saying that it's open for interpretation. As a fact, it was excluded.
Yes. I mean, me sitting here and knowing the background of the matters and the like, I don't think it's a mistake that it was not sent.
Yes. And then you have a very strange reference here, because Dr. Broughton says to them, on the Mdluli case, the SCA has spoken.
Yeah.
But the way they present that to the President and the Minister is to say that Dr. Broughton did not have the facts on the Mdluli case.
Yes.
Do you understand what that means? I mean, is this also an attempt to mislead, misrepresent the facts? What actually is going on?
That's how I understand it, because on the Dr. Broughton's analysis and his recommendation, this fact was there.
Yes.
That there's no basis, and it does not recommend that an inquiry should be instituted in respect of the Mdluli matter.
Yes. So that's what you wanted to address in relation to paragraph 47.7.
Indeed.
All right. Thank you very much. And that is what we've dealt with at 48, 49, 50, 51. Yes. Yes. In your statement at AC9, maybe you can go there now.
It's say AC9.
Yes. So it's 6A43. Remember that I was speculating about whether this was an inadvertent omission or a deliberate omission.
And here it comes, the part you've been waiting for. Chauke now drops the most shocking revelations of his testimony, exposing how key prosecutorial decisions may have been manipulated behind the scenes. This is the moment that could rewrite everything we thought we knew about the NPA.
Anyway, you asked for it, and then
But if, I beg your pardon, Counsel, if it was considered to be an internal memorandum, does that in itself suggest that it was confidential?
No, not at all.
Internal memos at the NPA, are they considered to be confidential matters even for people or advocates who are within the NPA itself?
Not at all. That's why I was qualifying it to the extent that it's confidential to the outside, but here it's a process that affects me, and this is about me. It cannot be confidential as against me.
yes.
Yes, I'd like to know if no charges were preferred against you, but as a DPP, wouldn't you be entitled to know what was happening within the NPA as one of the senior advocates there?
Of course.
Would such an internal memo be hidden against you, or would you be deprived from knowing about such an internal memo?
No, not at all. But as I say, Chairperson, this was about the specific conduct of me. Now it will not be in a position where if there is an EXCO meeting or whatever, it could not necessarily be discussed. Information could be said. We are in the process of doing this with Advocate Chauke. We are following the processes. But it is close to say this is what Chauke is doing and all sort of things. That I don't think she will do that because within the personnel matters, the practice is that you don't discuss one's as misconduct with another.
Yes, thank you.
Thank you.
Just one follow up. You have stated that Advocate Kock told you that he's surprised that the NDPP is still pursuing the issue of inquiry, notwithstanding the fact that he has written an opinion to the contrary. Now, the fact that this was actually disclosed to you by the author of the opinion, would that remain or become a confidential opinion?
Not at all. That's why I was saying that he informed me that he made a recommendation, but he's surprised that the recommendation is still being made.
Yeah, this I just ask over and above what my sister has already dealt with, but to say even over and above, the author never saw it as a confidential document.
No. Yes.
Now, it seems that when you made the request, you said, I'm aware of these documents, please give it to me. It was still not given to you if you look at AC8.
Yes.
Because AC8, which is at 6A/42, is a letter by you to the NDPP in which you say in paragraph 2, I do notice, however, that item 3.3, Advocate Rodney Kock's submission, after having received written explanations from myself on his request, was not included.
Yes.
Was there any explanation why they did not include it in the first response?
No, there was no explanation.
And then you said, considering that my written representations to the President are due on Monday, 7 April 2025, I would appreciate it if you could assist with this request urgently. So it's only in that context that on the 4th of April 2025, which seems to have been a Friday, at 5 minutes to 11 in the evening, that the memorandum was given to you.
Yes.
Literally with 1 day left before you made representations.
Yes, I can disclose to you, Chair, that she was always under the impression that I'm not aware of the Kock submission.
Yes. Now, there is a further disturbing element of this, the suppression of this information. When you look at the opinion, well, not an opinion, the letter from the NDPP in the correspondence bundle C, at C00024.
I'm there, Chair.
Yes. Yes. So specifically at page 00028. So this is a response to the minister who has asked two things. One, explain the delay in the institution of these proceedings. Number two, explain the existence of these various opinions. Why are you cherry picking, taking some and not all?
Yes.
Sorry, the president, but it's written via the minister.
Yes.
Yes. Now, if you look at C00028, Advocate Patoi's response in the third bullet point.
I'm there.
This is how she explains this. Deputy National Director of Public Prosecutions, Kock, considered these opinions and submitted a memorandum to the NDPP, wherein he expressed his own opinion on the matter and made a recommendation.
Yes. Yes, I see
Now,
that.
when you look at this, it's the second time it seems the president is being misled about what Advocate Kock said. Firstly, there was no disclosure at all.
Yeah.
And secondly, when there is a request about it, the explanation that is given is that he has expressed his opinion and made a recommendation.
Yes.
But there is no disclosure of the views of Advocate Kock.
What the recommendation is.
Yes. Now, wouldn't you agree that it seems that you have a scenario in which the decision makers are not being placed in a position to make an informed decision about your situation?
Indeed, that has always been my point, and I even raised this in my response to the president.
Yes.
Next.
Thank you. Now, I want to then go back to your statement. We've gone through up until page 20.
Yes.
And we looked at the implications of various judgments in relation to the case against Lieutenant General Mdluli. But there are also judgments in relation to the case of Cato Manor.
Indeed.
Yes. And two judgments in particular. First judgment is a judgment of Govan J. And the second judgment is a judgment of Lekhodi J. It has a full bench judgment with Madam Justice Hughes. The first judgment is referred to at paragraph 57 of your affidavit.
Yes.
The second judgment referred to at paragraph 60
Yes.
of your judgment.
Yes.
In your own words, can you just explain, there is a lot of misunderstanding about this case, which has been fueled by people with an interest in it. That essentially, Judge Govan exonerated the Cato Manor accused and proved that there was no case for